Good morning and welcome to the Courtroom Files Live. Getting a little bit of an early start this morning because I'm watching 7 different courts, and honestly, every one of them is just stacked with customers this morning. So let's get rolling, and we'll start with Judge Simpson.
And also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes, sir, I did.
Understanding all of that, you still wish to plead guilty.
Yes, sir, I did.
To the charge of use of a controlled substance, how do you plead?
Guilty.
To the charge of operating a motor vehicle without security, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form.
Yes, sir.
Any questions regarding any of those rights?
No, sir.
Look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading guilty in this case, you'll be waiving or giving up those rights as well as all the rights contained on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
Yes, sir.
Were you on probation or parole at the time of this offense?
No, sir.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
Doing this voluntarily
Yes, sir.
of your own free will?
Yes, sir.
And because you believe that you're guilty of these offenses?
Yes, sir.
January 12th, 2024, at the location of Evelyn Avenue, Hull Street, Ypsilanti Township, Washtenaw County, State of Michigan. Were you in possession of cocaine?
Yes, sir.
Had you used it?
Yes.
Did you know what you were using was cocaine?
Yes, sir.
And were you at some point also at that location operating a motor vehicle?
Yes, sir.
Did you have proper security or insurance on that vehicle?
No, sir, I did.
All right, counsel, have I complied with court rule and would it be proper to accept this defendant's plea?
People satisfied.
Satisfied, Your Honor.
Court will accept the defendant's plea of guilty to counts 2 and 5. Counts 1, 3, and 4 are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing will be
April 17th at 10 a.m. before Judge Washington.
April 17th, 2025, 10 a.m. before Judge Washington. Bond will continue. Thank you. Court calls the case of the people versus Alan Payne.
Rest in love of the people.
Your Honor, so it's time on behalf of Mr. Payne. You're up here to state your name. Alan Payne.
You're requesting an adjournment.
Yes, Your Honor.
How much time are you guys looking at?
The April 10th day was when that fell.
Shouldn't have asked. April 10th, 2025, 9 a.m. I know you were surprised I even did.
Thank you, Your Honor.
Thank you. Yeah. They're not up over. They're not there. Court does call the case of people versus Kane Kellenberger.
Rest in love of the people.
Your Honor, Senator Bernstein with on behalf of Keith Kellenberger.
Your name, sir?
Okay, Your Honor, hoping for adjournment.
Probable cause conference will be adjourned April 3rd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls the case of the people versus Ashton Dew.
Rest in love of the people.
Your Honor, no sign on behalf of Mr. Dew, lady, waiting in court. Ashton Dew. Your Honor, I have one epilogue from the discussion I had with Your Honor with Lonnie yesterday, which is the probate attorney is going to make an amended order. Trying to see that. I offered the court suggestion and hopefully that will work out. So.
Okay. If from this court's perspective, if there's anything else that's needed, just get to us and we'll take care of it.
Thank you. We certainly appreciate Your Honor's effort.
All right. And how much time are we going to be looking
I
at?
should go that April 10th. I know, but you asked. That was what
Is this your last case?
it is.
Cool. Probable cause conference, April 10th, 2025, 9 a.m. Or as your invite indicates, bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Mr. Simon. Have a good day.
You too.
This is another. I believe it's right there.
They have them.
Yes.
Court calls case People versus Nicholas Elka.
Good morning, Your Honor. Katie Wisniewski for the people.
Good morning, Your Honor. Sam Bernstein, Commissioner on behalf of Mr. Elko.
Hold on one moment. I don't know. I thought do they have it? It's longer than a second. I'm trying the patience thing. It's not working. No.
Well, while Judge is being patient, good morning again. Welcome to the Courtroom Files Live. I got us off to a little bit of an earlier start this morning. I've got eyes on 7 different courtrooms right now, and everybody's hopping this morning. Lots of crime yesterday, I guess. But let's continue with Judge.
Fine. I wasn't objecting to you. It's him.
While he's muted for a minute, let's jump over to Judge Meineke's court, where, as you can see on the screen, he's got a lot of people lined up as well.
Correct.
And so is Mr. Mathis.
And Mr. Mathis as well. Okay, so Ms. Walker, you're going to be pleading to allowing a licensed person to drive, as well as responsible to defective equipment and participate in Operation Drive. Allowing a licensed person to drive is a misdemeanor, carrying with it a maximum possible fine of $500 plus costs and up to 93 days in jail, all at this court's discretion. Mr. Giles, you're pleading guilty to operating while visibly impaired and speeding 1 to 5 over. The original counts of operating while intoxicated and speeding 16 to 20 over are going to be dismissed. Operating while visibly impaired is a misdemeanor, carrying with it a maximum possible fine of $300 plus costs and up to 93 days in jail, all at this court's discretion. Also carries with it 90 days of restricted driving. Mr. Mathis, you're going to be pleading guilty to allowing a licensed person to drive and responsible to impeding traffic. Allowing a licensed person to drive is a misdemeanor, carrying with it a maximum possible fine of $500 plus costs and up to 93 days in jail, all at this court's discretion. Impeding traffic is just a civil infraction. Actually, for both Ms. Walker and Mr. Mathis, you're both pleading guilty to the misdemeanor of allowing a licensed person to drive. And Ms. Walker, you're pleading to defective equipment. Mr. Mathis, you're pleading to impeding traffic. The important thing that you should both know is that none of these charges go on your driving record. So your efforts to get your license back will not be impacted by this plea. Ms. Haynes, you're pleading guilty to using fraud or deceit to obtain a controlled substance. That's a misdemeanor, carrying with it a maximum possible fine of $500 plus costs and up to 90 days in jail, all at this court's discretion. However, you're being afforded the chance to keep this off of your record because of your age and your qualification for the Homes Youthful Training Act. I have to agree to give that to you, but you do seem to be a good candidate, and I would be willing to consider you for that program to keep this off your record. Okay. All right. If you would all please raise your right hand. All right, Ms. Walker, Mr. Giles, Mr. Mathis, and Ms. Haynes. All right. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Walker?
Yes.
Mr. Giles? Yes, Mr. Giles.
Yes.
Mr. Mathis.
Yes.
And Ms. Haynes.
Yes.
All right, you can go all put your hands down. Ms. Walker, can you read, write, and understand the English language?
Yes.
Can you hear and understand me?
Yes.
Mr. Giles, can you read, write, and understand the English language?
Yes, sir.
Can you hear and understand me?
Yes, sir.
Mr. Mathis, can you read, write, and understand the English language?
Yes.
Can you hear and understand me?
Yes.
And Ms. Haynes, can you read, write, and understand the English language?
Yes.
Can you hear and understand me?
Yes.
All right. Before you enter a plea, each of you should understand you have the right to represent yourself or be represented by an attorney. If you cannot afford an attorney, want to be appointed for you at public expense. You have the right to a trial, either by me or by a jury. At that trial, you'd have the right to confront, cross-examine, question all witnesses brought against you. You'd have the right to have the court subpoena witnesses on your behalf. You'd have the right to testify if you wanted to, remain silent if you wanted to, and no one could say anything about you remaining silent. As you appear before this court, you're presumed innocent of this charge, and your guilt has to be proven beyond a reasonable doubt. Ms. Walker, do you understand that once you enter a plea, you give up all those rights that I just said that you have in a trial?
Yes.
You understand that, Mr. Giles?
Yes.
You understand that, Mr. Mathis?
Yes.
And do you understand that, Ms. Haynes?
Yes.
All right. Ms. Walker, do you understand that once you enter a plea, there'll be no trial?
Yes.
You understand that, Mr. Giles?
Yes.
Mr. Mathis?
Yes.
Ms. Haynes?
Yes.
Each of you received some type of plea bargain, all right? Either a reduction in charge or access to a diversion program, something that has been made to encourage you or as part of a deal to get you to plea. Other than what's been placed on the record, has anybody else promised you or threatened you in any way to get you to give up your rights and enter a plea? Ms. Walker,
No.
all right? Mr. Giles,
No.
Mr. Mathis,
No.
Ms. Haynes.
No.
In the end, is it your own?
So he's taken a bulk approach, but it's all fairly pedestrian. Let's go back to Judge Simpson.
I'll grant the adjournment. All of your fellow counsel here, nobody told you about the green sheet you needed to fill out. Oh, no, that's not on you. There's all of these people over here that could have helped you out, especially Feaster. And he didn't help you out. That's okay. So I'm gonna talk, I'll deal with Feaster. It's not on you. How much time did you need?
I guess about 2 weeks.
All right, fantastic. Probable cause conference, April 3rd, 2025, 9 a.m. Bond in this matter will continue. Thank you. And if you can just fill that out and get it to us, that'll work out. Court calls the case of the people versus Romerio Butler.
Joseph, you don't have to keep me on? Morning, Robert. Judge, I was just wondering on this matter. Can you give me?
Probable cause conference, April 3rd, 2025, 9 a.m. Bond continued. Court calls the cases of the people versus Taiwan Browning. 4 cases.
Good morning, man. Please don't report. Please, John. That's all location, John.
Your name, sir? All right, what are we doing?
Yeah, this time I'd like to set the matter for.
All discovery is complete.
Yes, no, that's to all cases.
First is going to
Yes.
people have their witnesses available on these cases April 1st.
I will make sure that I set up most of the police officers, so I don't see a problem.
Preliminary examination, April 1st, 2025, 9 a.m. before Judge Perry.
Yes.
Did you say April 1st?
Yes,
Okay.
before Judge Perry. Bond will continue. Thank you. Court calls the case of the people versus Kyle Burmeister.
James Badowski, appearing on behalf of Councilor Please, sir. Kyle Brian Burmeister. Your Honor, we are requesting an adjournment to possibly resolve this case along with his other pending misdemeanor case Ms. Londy has. So I'd be asking for a 2-week adjournment, and then I can address the bond issue.
You need to address the bond issue before I'm going to give you an adjournment.
Your Honor, my client tells me he never had noticed that he had to go to community corrections on this case. And I am looking at the court activity from this file, from the arraignment that he was given. It only indicates bond amount 5,000, personal recognizance. There's nothing listed in the condition section. I went through all this paperwork and said he's kept everything.
Except he was advised on the record that he would be subject to drug testing on that same date by Magistrate Odetella, and I have that form. So I'll match my form against yours anytime.
Well, all I can add, Your Honor, is that he actually had.
Why didn't he go?
Inpatient treatment.
Did he go over?
He tells me he didn't. either recall or didn't have anything to explain, I think once he was released from jail. Any paperwork that said I gotta go. And so maybe with the confusion of these cases, the good thing though, Your Honor, is I have verification. He went to the JIRA residential from February 25th. And he completed that actually early on March 7th. He can test today. He's telling me he should be fine. He is not in.
I'll pass it. He needs to get over there and test now.
Thank you.
Court calls case, People versus Maurice Anthony. Can you let him know he's been?
Got to reach these three matters. Jonathan,
This is public defender Kelsey Reveal, on behalf of the parties here today, Mr. Anthony.
Where's it?
Go ahead, counsel.
Your Honor, Mr. Anthony would like to waive his right to a preliminary exam on all three cases.
And all three. Is that a correct statement, sir? You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them. You understand you'll not have hearings in any of these matters, and you'll proceed to circuit court for further resolution. People also waive their right in these cases. Preliminary examination having been waived, defendant is bound over to circuit court on the two counts contained in the case ending in 600 and one count in each of them. Go ahead, counsel.
Your Honor, we would acknowledge receipt of the information, waive its formal reading, and stand U.S. to the charges.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to all charges. Pre-trial in these matters will be set for April 2nd, 2025, 1:30 before Judge Conlon. Bond will continue in these cases. That was April 2nd. Yeah, I will. Court does call the case of the People versus Brendan Chrysler.
Chrysler. Your Honor, Mr. Chrysler had a medical situation and currently is at Quality Behavioral Health, which is a residential program. I have a letter verifying this. I spoke to their staff this morning. Essentially detox rehab. So he's not able to be here. I've shown this to Ms. Lowney. My request in any event, because I'm new to this file, is for an adjournment. Court can put it out a couple of
People have,
No, Your Honor, I have been to be in detox. I didn't realize it was, it's fine, that's fine. Perfect. Sounds great.
April 3rd, 2025, 9 a.m. Bond continue.
Thank you very much. Your Honor.
Court calls case People versus Daryl Hick.
Morning, I understand firsthand what's on behalf of Mr. Hicks.
Sir, your name? Thank you.
In this case, we've been awaiting further discovery, specifically CT scans and MRIs. I did just receive a supplemental report that what I've been asking for has been in his possession. The sheriff's department's at 214, so hopefully that gets to me right away and get this moving.
Who's this? Who is this?
That's not.
Oh, that's previous. Got it. So how much time? Pardon?
Hoping for an adjournment to accomplish that. Your Honor.
Will 2 weeks be enough to get
Yeah,
that?
sure. I thought that the CT scans were sent out to council, but they haven't. So
Gotcha.
I think-
April 3rd, 2025, 9 a.m. Bond continue. Calls the case of the People versus Lawrence Buckner.
And is it on track to be there?
Okay.
Judge Fleischer has come online this morning. His courtroom doesn't look as busy as the others, but let's see what's going on.
Away, and then I'm going to put you in jail. Do you understand? I will protect my street at all costs. If that means putting you in there with an extremely high bond, I'll do it in a heartbeat. No reckless driving, street takeovers, donuts, anything of this nature. Do you understand? You are also not allowed to drive unless you have valid liability insurance in your name as well. All of these are your bond conditions. If you will have you sign these bond conditions now, you pick up a new case. If I find out anything, do you understand? Now, because you have a lawyer, I will waive your appearance, so you don't have to waste your time coming to court, but you must stay in touch with counsel. If he tells me he can't get a hold of you, you pick up a new case, you act like a bonehead. It's not going to go well for you. Do you understand? All right, I'll have you sign a reset with Victoria. We'll have you meet take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go.
Thank you.
Thank you. So do you mind filing those conditions?
Did you want the case number?
Yeah.
5555528. Lundy, come on up.
Morning, Your Honor.
That way. Well, good morning. Top of the, it's Friday Eve.
Yes, happy Friday.
Wednesday.
Did you get it, the cost number?
Yes, I did.
Yeah. Okay. Good morning, Mr. Lundy. Sir, you're charged with failure to stop and give information, which is leaving the scene of an accident without exchanging information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 12th, 2025, at approximately 4:45 p.m., an officer was dispatched to an FSGI call. Upon arrival, the officer spoke to the complainant, who stated he was traveling north on FM when a vehicle crashed into his vehicle. The driver then fled the scene without exchanging information. Complaining witness to the passenger stated that they were rear-ended, causing the defendant's vehicle to crash into a ditch. Defendant then approached them to check on their welfare, and once he saw they were unharmed, the defendant fled the scene on foot. The officer observed significant rear-end damage to the complainant's vehicle. The complainant provided a description of the defendant, and the officer ran the license plate and found the registered owners were Michael Lundy and Dylan Lundy. On March 13th, 2025, the officer received a call from Dylan Lundy, who wished to provide a voluntary statement regarding the incident. The defendant admitted to crashing into the complainant's vehicle and to fleeing on foot because he believed he had an open warrant for failure to appear for a window tint violation. The complainant positively identified the defendant by photograph. The estimated cost to repair was over $200, as the complainant believed their vehicle was totaled.
Okay. Can you run his license, please? And does he
Yes.
have any open cases anywhere? You can run an NCIC.
His driver's license is eligible, and I normally don't take note of Class C violations, but I do.
No, I don't care about Class C.
Right.
Didn't-
Um,
No, I don't care.
He does not have any open
Nope.
cases
Okay.
at the moment.
Got it. All right, Mr. Lundy, I'm going to find there's sufficient probable cause to go forward with the case. The only condition I'm placing on you now is you are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If you do not have car insurance, you may not drive. You understand?
Yes, sir.
Okay, I will waive your appearance because you have a lawyer. Just stay in contact with Will. He'll tell you if and when you have to come back to court. I'll have you sign a receipt, Victoria. We'll have you take a seat while we get your conditions. You'll sign it and then you'll be free to go.
Thank you, Judge.
Don't
Thank
pick up
you,
any
yeah.
new cases.
Yes, sir.
Is that pre-trial bond condition?
State's conditions.
Okay.
Okay,
Next is
so-
on page 12. Howard, come on up.
Can you file those, please?
Good morning, Your Honor.
Hi, how are you, man?
I'm doing good, Judge. How are you?
Good.
Good.
What was the last name?
Howard,
Okay,
page 12.
there we go. Right. Good morning, Ms. Howard. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, ma'am.
On March 16th, 2025, an officer observed a vehicle driving the wrong way on Durham Drive in Harris County, Texas. The officer asked the defendant to step out of the vehicle. The officer observed the defendant to have bloodshot eyes and the moderate odor of alcohol emitting from her. The defendant stated she was coming from Clutch Bar and had one shot. The defendant stated her GPS told her to go the wrong way. SFSTs were conducted. 4 out of 6 clues were observed on the HGN. 3 out of 8 clues observed on the walk and turn, and 1 out of 4 clues observed on the one-leg stand. The DIC was read and the defendant consented to providing a breath sample. The results were 0.119 and 0.123.
Okay, Ms. Howard, I'm going to find that there's sufficient probable cause to go forward with your case. Do you mind running to see if she has any prior DWIs, please?
Yes, Judge.
And a license?
She does not, and her driver's license is eligible.
Okay. I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using, I will revoke your bond, put you in jail. No more PR bonds. You understand, ma'am? You have a lawyer, he'll help you out. Just stay out of trouble. Don't pick up any new cases. If your license does get suspended, you may not drive, and Con will keep you in the loop. For now, I'll have you sign a reset with Victoria. We'll have you get your conditions with Felicia, and then you're free to go. Thanks, guys.
Thank you, Your Honor.
Have fun. Good to see you.
Good to see you too, Judge.
Page 16, Phillips, come on up.
Morning, Judge.
Hi. You say 16? Okay.
Phillips.
Good morning, Mr. Phillips.
Good morning, Your Honor.
Sir, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
On March 12th, 2025, at approximately 9:25 a.m., an officer was conducting a stationary traffic enforcement on a public roadway of the 7,000th block of IH 610 southbound in Harris County, Texas. The officer observed a red Ford pickup truck traveling at a high rate of speed with heavy traffic and the posted limit was 60 miles per hour. The officer witnessed the pickup truck bypassing other motor vehicles, weaving in and out of traffic at high speeds and coming dangerously close to other motor vehicles, with other drivers having to brake to avoid collisions as the Ford cut in front of them recklessly. The officer witnessed the pickup make multiple unsafe lane changes. A traffic stop was initiated. The officer reached speeds up to 110 miles per hour to catch up with the truck, but the pickup continued to distance itself from the patrol vehicle. The officer made contact with the defendant, driver, and sole occupant. The defendant admitted, "I know I was driving like an idiot. I just got off work." The defendant acknowledged he was aware that he could have caused an accident and hurt someone.
Mr. Phillips, I'm going to find that there's sufficient probable cause to go forward with the case. If I find that you drive like this again, it's really not going to go well for you. Do you understand?
Yes, sir.
I will protect my street at all costs. If that means putting you in jail with a $500,000 bond, I'm going to do it in a second. Do you understand?
Yes, sir.
Anymore, I will also take your privilege to drive away from you as well. Can you look to see if he has a license?
Yes, his driver's license is eligible, Your Honor.
You are not allowed to drive unless you have valid liability insurance in your name, and that is also now a condition of your bond. No reckless driving, maniacally driving, donuts, street takeovers, anything of this nature. Do you understand?
Yes, Your Honor.
You will sign conditions to this, and after that, you'll be free to go. You have a lawyer, I will waive your appearance. Just keep my street safe, man. Every day we have people dying. It's not fair. Do you understand?
Yes, Your Honor.
Okay, come on.
Thank you, Judge.
Right this way. All right, Judge, next is page 1, Al Bardon. Come on up. All right, house May 22nd.
I can work like this. Stand right here in the middle. I'm the judge.
All right, go ahead and have some.
Yes, sir. Thank you.
You can call Flores up now if you want to sign conditions as well. Sign those. What page did you say?
Page 1, top of page 1.
You were Mr. Albardon? Sir, you're charged with terroristic threat of a family or a household member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thomas
On
Flores?
March 12, 2025, an officer responded to a weapons disturbance call at a residence in Katy, Harris County, Texas. Upon arrival, the officer met with the witness who stated the defendant, her brother, and the complainant, her sister, were inside the residence and were involved in a verbal disturbance. The witness believed the defendant walked upstairs to retrieve a firearm during the altercation, which caused her to walk out of the residence and call 911. The witness, the complainant and the defendant were eating at the dinner table, and the defendant told the complainant that he will shoot the complainant and the complainant will need to leave the residence. The complainant stated that she lives at the residence with the defendant. The complainant stated the defendant got into a verbal altercation with their father, and the defendant stated that he was the man of the house. The defendant attempted to slap the complainant in her face, and the complainant moved her head back, causing her hijab to fall off her head. The defendant told the complainant he would grab a gun, hold her down, and shoot her. The defendant would see that the complainant would not be in the residence. The complainant stated she felt in fear when the defendant threatened to shoot her.
Mr. Alvarado, I'm going to find that there's sufficient probable cause to go forward with the case. A protective order has been issued in this case that identifies Ms. Lubna as a protected individual. Get to know this protective order, because if you do something to violate it, the state can and will file a violation of a protective order against you. And it's one of the worst cases that you can pick up. Do you understand? One of the things is this comes with a residential restriction that you're not allowed within 200 feet of the Park Fair courthouse. Do you understand? If you go back to this place, it's not going to go well for you. Do you understand? How old are you, sir? How much? 33. Do you work? Do you have the ability to hire a lawyer? So what I'll do is I'll have you fill out an application for me. I need to know whether you can qualify for a court-appointed lawyer. Any allegation of alcohol or McKenzie, any alcohol or any dope, anything like
No
that?
allegations of alcohol.
Okay. So for now, what I'm going to do is I'm also ordering you not to have any contact with this person and not to be in possession of weapons. Do you understand? I'll provide you a lawyer today and we can talk about how we go forward, but just be careful. I don't want to have to put you in jail. Do you understand? Okay. Do you mind giving me an application? Deputy Miranda's going to give you an application. I'll have you sign a reset with Victoria, and then we'll have you take a seat in the jury box.
Real quick from Mr. the Courtroom Files here. The I'm the man of the house defense. Give me a break. And then we find he doesn't have a job. He's not working. Maybe I'm old-fashioned. Tell me if I'm wrong in the chat, but I don't see how you can claim I'm the man of the house when you don't even have a job. And quite frankly, if I use that whole I'm the man of the house line on Mrs. the Courtroom Files, she's scrappy. She'd kick the crap out of me. I don't know. That one just hit me wrong. But let me know what you think in the chat.
Okay. Definitely no weapons,
Definitely no weapons. We'll talk about it.
Yeah, okay. Frederick, do you have an arraignment?
Good morning, Judge. I don't think I have an arraignment, but I do have.
Do you mind? Please, thanks. Hold on, I can't hear you.
Let me.
Give me a second.
Judge.
No? Okay. Are you ready?
For the next one?
Yeah.
Page 6, Bird.
Let me just blow through the arraignments, Frederick, and then I'll hit you up, okay? Please. I don't think there are many. Say something.
Hello, Judge. Can you hear me?
Go. Okay.
All right, got it.
Thanks. I just need to make sure it's the speaker's on. Hi, Sylvia. Do you have an arraignment? No?
No,
Okay,
sir.
let me finish with this and then I'll hit you guys up.
Sure, absolutely. Good morning.
Bottom of page 6, Judge.
Good morning, Miss Burse.
Sorry, I lost my voice.
Burse, that's what's right?
Yes.
Okay, ma'am, you're charged with criminal mischief. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. Just hang tight and we'll, okay?
On March 13th, 2025, an officer responded to a criminal mischief call at a residence in Harris County, Texas. The officer made contact with the complainant and the witness who directed the officer to the scene. The complainant stated the defendant came to the location, broke his motor vehicle window, and reported the incident on his phone for the officers to see. The complainant stated the defendant left the location in a black Kia that had the location on. The complainant stated the defendant was on Rust Creek Drive at an apartment. He could point to her apartment. The cost of the damage to the motor vehicle was approximately $500. The officer reviewed the video and observed the defendant striking the front passenger window, causing the window to shatter, then leaving the location. The officer observed a brick inside the motor vehicle with glass shards inside the front passenger seat, floorboard, and outside the motor vehicle. The complainant was positively identified by her Texas ID prior to driving to her location per GPS. The officers followed behind, and the complainant pointed at the apartment as the defendant was standing right outside of it. The officer made contact with the defendant, who was wearing the same outfit in the video, and the defendant admitted to breaking the complainant's window.
Got it. Do you have the rip done? I'm assuming this complainant doesn't want to have contact with her?
We do not have, we have.
Not yet? Okay. Ms. Burse, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to have any contact with this person. Do you understand?
Yes, Your Honor.
I don't care what's going on in your life. Don't have any contact with this person. I'm also ordering you not to be in possession of your weapons as well.
Okay.
If I find that you're a danger to my community, it's not going to go well for you. Do you understand?
Yes, sir.
Do you have the ability to hire a lawyer? Are you sure?
Yes.
Do you want to apply for a court-appointed lawyer?
If I really don't need one, then no.
You need a lawyer.
Okay, then
You're facing 6 months in jail,
then yes.
$2,000 fine, plus it could go on your record, and it's disastrous when it goes on your record.
Yes.
It's a good idea. Do you mind giving her an application? So I'm going to have you fill out the application. I'll have you take a seat in the jury box. So we'll get your bond conditions. Do not leave until you sign them. And then
Okay.
I'll have you talk to a lawyer here momentarily. So can you file no conflict, please? Please. Did you say she also doesn't have a license?
I did
I
not.
thought I heard you say that.
No, I did not say that. She has a driver's license number. I can run it really quick.
Yeah, do you mind? Because one of the things is she was left in the Kia, right? So let's see if she has a license. If not, I'm not gonna let her drive.
We're almost done. All right, Jennifer,
Her driver's
driver's
license is on.
Okay, great.
is page 15. Miller, come on up.
So while we're waiting for that, I got my eyes now on 11 different courtrooms, and every one of them is packed with arraignments this morning. But we'll continue to ride with Judge Fleischer for a little bit.
All right, good morning, Mr. Miller. Sir, you're charged with harassing communication. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
The complainant informed the officer that on November 9th, 2022, in Harris County, Texas, the defendant was sending the complainant harassing text messages to the complainant. The complainant and the defendant had been in an on and off relationship and had recently ended it. The defendant would call and text apologies that he would love her. The complainant stated eventually that the defendant started conveying messages that were angry in context. The complainant blocked him in response, and then she began receiving calls and texts from unknown numbers. The complainant even asked the defendant's mother to tell him to stop calling her. The complainant stated that the night that she received calls and that That night, she received calls and texts from the defendant with him threatening to call Child Protective Services. The complainant and the defendant were using an app and calling and text. The defendant was using an app and calling and texting from different phone numbers, and he sent multiple phone numbers and different text messages that are outlined in the officer's report.
Gary Phillips.
Are we
Bill
talking
Buckley.
like tons of text and stuff? How many are we
Yes, sure.
talking?
Tons of texts from different phone numbers. After the complainant had repeatedly told him to stop.
Okay, I see. I'm looking at dozens and dozens. Okay. All right, Mr. Miller, I'm going to find there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have any contact with this person. I don't care what medium it is. I don't care if it's a smoke signal. I don't care if it's with Snapchat, WhatsApp, social media. If I find that you do, I will revoke your bond and put you in jail. Do you understand? No means no. Just, you don't have children with this person. Move on. 10,000 other fish in the sea. It's not worth it sitting in a 6x9 because of one person, right? So, all right. I'm also ordering you as a condition of your bond not to be in possession of any weapons as well. Do you have the ability to hire a lawyer?
Yes.
Okay, so what we'll do is we'll give you time to hire a lawyer. I'll have you sign a reset with Victoria. We'll have you take a seat in the jury box. We'll get your bond conditions. We'll have you sign it and then you'll be free to go. All right, please.
And is that state bond conditions?
Please.
Yes, sir.
No contact and no weapons.
All right, Judge, next is page 21, Runyon. Come
And
on
then
up.
if you don't mind, Abigail, would you mind reaching out to the person to let them know that we've placed these bond conditions in the event that she starts getting anonymous
Yes, Your Honor, we have been in
to let you guys know?
contact with her since the case has been
Great.
filed.
Good morning, Mr. Runyon. Sir, you're charged with illegal dumping. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
January 23rd, 2025, a witness stated that he saw the defendant dump a sofa on the 22-800 block of Fair Lake Lane on Tuesday, January 21st. The witness stated that he was cooking and looked out of his kitchen and saw a truck and the defendant come out to dump it. And the witness took a photo of the defendant's license plate and of the defendant. The witness told the defendant that you can't dump trash there, and the defendant looked up at the sofa he already dumped and left. The witness stated he was concerned the defendant was going to dump the sofa at a nearby location. So the witness drove to the main roadway near his house and observed the sofa had been dumped at an abandoned car wash located at 11440 FM 1960 in Huffman, Texas, which is not an approved dump site by the Texas Commission on Environmental Quality. The witness is positive that the sofa is the same brown sofa that the defendant dumped near his house previously.
But he didn't see it.
No, Your Honor, but he did it was the same sofa, and he did follow, and then at that point, the sofa was still on the side of the road. Yeah. The witness stated he was cooking, looked out his kitchen.
I know that he sees it. So he doesn't dump it that first time. He goes to a location, he's about to dump it, but he doesn't, he takes off.
So
Right.
I would just request, this is not with us, this is with environmental. I would just request we hold off on PC ratings until the prosecutor hears it's based on.
Okay, I mean, I'm willing to hold it, but you know,
I get it. I just want to make sure the prosecutor.
Mr. Runyon, just take a seat for me in the jury box, please.
All right, Judge, next is an off docket arrangement.
I got it.
Has it up there?
Yeah.
Dave, do you have the case number for the Lasana?
No, I do
You
not.
ready?
You ready?
Yes.
2549470. The Lasana, come on up. Some cases.
I have it, thank you.
Right here. Has that.
You were Alan Villasana. Mr. Villasana, you were charged with 2 cases. You were charged with theft. You were also charged with racing on a highway. On both of those cases, you were facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
The theft or the racing?
Yeah, start on the theft because it's the earlier one, yeah.
On January 1st, 2025, officers were dispatched to a shoplifter call at a Target in Harris County, Texas. The complainant, the loss prevention employee, called the officer regarding a theft in progress at the location and observed a Hispanic male wearing a tan hoodie and black shorts making a selection and removed the security tape from a JBL speaker box and placed other products inside the shopping cart. The complainant proceeded to keep the surveillance on the male and observe the defendant proceed to exit past all points of sale without any intent to pay for the items. The officer reviewed the surveillance and observed the complainant make contact with the defendant at the front entrance and attempted to retrieve the stolen items, and the defendant proceeded to leave the Target and enter a black Chevrolet Spark. With the assistance of a license plate reader and TLO, the officer determined the motor vehicle to be driven by the defendant and obtained a Texas driver's license, which the officer believed completely matched the Hispanic male captured on the surveillance footage. The total taken was $499.03.
Okay. On the racing, please.
Yes, Your Honor. On March 15th, 2025, the officers observed a black Toyota Camry and a silver Chrysler sedan traveling at a high rate of speed on the main lanes of the Katy Freeway. Officers attempted to catch up to the motor vehicles traveling 120 miles per hour to keep the motor vehicles in sight, but both motor vehicles were still out gaining speed. The posted speed limit was 65 miles per hour. Both the defendant and the silver Chrysler were racing in competition side by side at points, with both motor vehicles accelerating at a high rate of speed, attempting to outdistance and outgain each other. While the defendant and the Chrysler were racing, they were making evasive lane changes and failing to signal lane change, cutting off multiple motor vehicles to get around traffic, causing victims with their motor vehicles to take evasive actions to avoid collisions. The defendant's motor vehicle at one point drove on the right shoulder to pass vehicles in the right lane and was in front of the silver Chrysler. A traffic stop was initiated.
So driving on the shoulder to get.
A traffic stop was initiated and the officer made contact with the defendant, who was the driver. The defendant admitted that he was racing with the other vehicle and that this was not his first time racing, but his first time arrested, and that he would have ran from the officers if he had more gas in the motor vehicle.
Mr. Villasana, I'm going to find that there's probable cause to go forward on both of your cases. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke the bond on both of your cases and I'm going to put you in jail. I'm also ordering you now not to drive. You will be signing an affidavit with me today promising me you're not going to drive. Do you understand?
How long?
While this case is open. And if I find that you do, likewise, it's not going to go well for you. Do you understand?
Yeah.
Can you print me out more affidavits, please? You're not to go to any Target whatsoever as well. If I find that you pick up a third case, it's really not going to go well for you. Do you understand? I'm going to do everything in my power to protect my city at all costs. And if that means putting you in jail and making your bonds high, I'll do it in a heartbeat. Do you understand? Do you have the ability to hire a lawyer, or would you like to apply for a court-appointed lawyer?
I don't have a job right now, so I can't.
Okay. Deputy Miranda's going to give you an application. I'll have you fill it out and I'll take a look at it with you. Hey, I'm not done talking to you. I'll have you take a look at I'll have you fill it out. I'll take a look at it. I'm going to have you sign a receipt with Victoria. I'm going to have you come back because I'm going to have you sign an affidavit with me today promising me you're not going to drive. And then you'll get with Fleischer for your bond conditions.
I won't be able to come back. I don't have a ride.
Figure it out. I'll get you a lawyer and we'll start talking. But I don't want any more problems. Do you understand?
No, I haven't been in public like 5 years. This is the first time I had a case since five.
Don't, please.
Go ahead and sign for your receipt, please. All right, you come in for the Senate. Sorry.
So just to be clear, no job, a massive attitude, but he hasn't been in trouble in like 5 years. I don't know. Let's go over to Judge Simpson's court for a minute and see what's going on over there.
On July 31st, you gave me a chance, you put me on probation,
Oh, I remember.
and you told me never to give up. Ever since then, I have been compliant with probation. I have been part of the Pathways of Recovery program. I'm very involved in the recovery program out here. I'm actually from Wayne County, but since probation, I've been out here. I'm in recovery every day, and the $100 bond is just something I wasn't able to get out of the Western Union with my lockup, and I would really benefit from a personal bond. I never got to talk to my.
Your Honor, I will just say, Mr. Content has bond set at $1,000, 10% on this case, and $100 on his other Washington County case. He does have a couple of holds on him. I'm not sure if they're holds that would result in him actually being kicked out. I believe some of them may just be traffic related. But if Your Honor would consider maybe lowering the bond to $100, 10%, just so it's something that he could afford to post. And if
The other one was $100 personal bond. Yeah, it was a personal bond.
Your Honor, you consider amending the bond to a lower amount or granting Mr. Collinson a personal 5% bond.
Response.
So it does appear that in October of 2023, the defendant had been charged with possession of methamphetamine, and we allowed him plea to use. I think that's the case he's referring to that he's put on probation for. In this matter, police had contact with him on March 8th, 2025. He was found to be, I believe, in possession or to have illegally used someone else's credit card. A substance was found on him, and we just got the lab report back that came positive for match. And he gave a fake name to the police officers. So I actually think the bond is extremely low. We originally asked for a $25,000 surety bond, and I think he has 5 holds. So I frankly think the bond has been set extremely favorable to the defendant.
And Your Honor, I do agree that he does have 5 holds.
He has 5 holds.
5.
Oh,
Yes.
5,
Again,
like
several
crab
different-
5
Right, exactly like that. Yes.
or Michigan seating.
Exactly. Yes,
Okay,
Your Honor.
okay.
That's fine. Several and yeah, the name he gave when he had contact with Officer Stinky from Ann Arbor, I believe it was Jacob Collinson.
Motion for bond reduction is denied. Bond will continue. Thank you.
Thank you.
Court calls the case People versus Antoine Coleman. Hey, do me a favor. Go over and shake Kennedy and ask him why he's wearing gold. Just ask him. No weapon is immediately needed.
Mr. Cole, please state your name on the record.
That's why we told.
All right, what are we doing on this? Mr. Speaker?
Not gonna have a judge.
What'd you say?
Not gonna have a judge. Mr. Evans and I tried to discuss potential resolution for this matter. I'm asking for a little more time to go over some for Mr. Coleman.
All right. How much more time did you guys think you needed? 2 weeks. Probable cause conference without objection, April 3rd, 2025, 9 a.m. Bond continues. Okay. What do you say?
Get it done. Get it done.
What? What?
I want you to know, in my bracket, I have Maryland going.
Your bracket.
In mine.
Oh,
I
on
have
yours?
Maryland going to the Big Ten. Oh, wait, it's the Elite Eight. The Big Ten is the thing that Michigan won.
You still got cases. You keep it up.
I'll be here all day.
Yeah, but depends on in the courtroom or in custody. I don't know. All right, thanks. Court calls the case, People versus Devin Gauther. See, he took it too far. It's gonna be a bad day for Kennedy. Bad day. Bad day. Thank you.
Your Honor, we're asking for an adjournment. There's some additional discovery that we can have.
2 weeks.
Yes, please.
Probable cause, like I care. Probable cause conference. April 3rd, 2025, 9 a.m. Kennedy, you should have never started with me. It's not gonna be good.
Thank you.
Thank you, Bonnie, too.
Thank you.
Court calls the case, People versus Jesse Crampton.
Brian Mulligan, Mr. Crampton, Your Honor. Your Honor, for purposes of discretion, the reason Mr. Crampton is not here is on that green piece of paper, and I didn't want to put it on the record, which I think you'll understand if you read it.
Got it.
To Mr. Benville about this case, based on the reason on the record, I would ask for it.
No, under the circumstances, people don't know.
You said that's the shortest amount of time. When you put at least, it's gonna be.
Yes.
Got it.
Yeah.
That's fine. All right. Probable cause conference will be adjourned May 22nd, 2025, 9 a.m. Thank you. Cause case, People versus Yusuf Jama.
Under Hannah Appleton on behalf of Mr. John Winston for the record.
Thank you.
Your Honor, we're asking for an adjournment. There is some mitigation and some information.
Let's hop back over to Judge Fleischer's court.
It's A, but it was actually a class B. All right.
So we can
It's-
do a nunk.
Well, we thought that we could. I mean, that, I'm not sure if that's an option or not.
I assume so.
I'm hoping that it is.
You can do anything you want until someone says no, right?
Yeah, right, that's right. I don't think anybody is going to object. We're bringing it to you, so we're not objecting to it. And of course, it is a case that was handled by the Public Defender's Office. And
So, okay, so you're for the state then?
yeah, absolutely, Your Honor. I'm
Sorry.
Senior counsel for the district attorneys.
I need to get the defense lawyer then. I thought that you were
Okay.
defense.
All right, I apologize for not
It's
introducing myself.
okay. Can I have the cost number? Do you mind?
I will give you the cause number. It's 255-4843.
Let's see.
01010.
Okay.
And so my position now is senior counsel in the district attorney's
Okay.
office.
Let me get a hold of Ms. Strong real quick, and then I'll have her come down, and then we can talk and figure out how to.
We'll just
Go forward.
coordinate it with their coordinator. you like me to?
It's up to, I mean, I've got her phone, and she's here every day.
Okay.
So let me see if she's here, and then that way, if you give me just a couple moments, I'll see if she can run down.
Great bow tie, by the way.
Case for her on docket, but I'm not, you know.
Do you have something here
I
today?
think so. I was running the docket.
She's really great about showing
Yeah,
up,
she's-
so,
We
she
always
has the
love
case,
that,
so,
don't we?
yes.
She's aware of you, so.
All right, I'll stand down, Your Honor. Thank you.
Yeah, give me 5 minutes, let me get a hold of her,
No problem.
and then,
Okay, no problem. I was.
why not?
Because the defendant got released yesterday, so we had to do a motion for no trial. As I talked to the supervisor about this case, because we got the email about this case. And that the plea already went through, judgment was accepted, the charge, like, he already finished his 10 days in custody, so 39+3 on the judgment. And he went in 10th, he got released yesterday. So my supervisor was saying he wouldn't be able to do it now because it was a state's issue or wasn't amended before the plea was taken.
Council for reset?
Because usually enough is whenever there's a clerk error, but they let me know that there was nothing.
Ms. Strong? Hey, it's David Fleischer. Hey, were you here tonight? No. Can you pop in Zoom later? Here's the deal. So, no, we have a guy that we played, Michael Jones, I don't know if you remember. And we played him, and it looks like the plea was done wrong. It was pled, yes. Hey.
Real quick while Judge continues with his phone call. Good morning again. Welcome to the Courtroom Files Live. If you've joined us late, welcome aboard. It's good to have you here. I wanted to take a second and give a personal thank you to all the viewers of this channel. Yesterday was actually the biggest day that we have had in the history of the Courtroom Files. We had over 200,000 people tune in to our channel from around the world to watch our short form, our long form, and our live stream. And I just want to say I really appreciate that. You know, we started this channel just in October, so not that long ago, and the growth that we have had has just been outrageous, and it's been a lot of fun. And I really enjoy interacting with you all. And to that end, I'd like to encourage more interaction in the chat on the live stream. So if you're with us and there's things that you see that you want to comment on, please do so. And let's promote that and have fun with that. We have a very active community in the comments on our shorts and our long form content, but the live stream is new and it is something that we're building, and I realize it's a slightly different audience, but I appreciate any participation that you can do. It also helps teach the algorithm that this live show exists and should be shown to others. Obviously, the algorithm loves us already, but it hasn't figured out that we have a live show yet. So smashing the like button and participating in the chat are appreciated. And again, a heartfelt thank you to everybody who's tuned into this channel, because yesterday was huge. Today is doing really well as well. And I just want to say I appreciate it. All right, let's get back to court.
New trial.
That's fine.
Do you want to file it and then I can grant it?
I don't, can I file it as a
And that's
state?
what I'm, that's have to do it, or we have to do it. I'm fine with doing it. We have to do it. I just didn't know if. Are we allowed to do it?
I don't know.
I
I don't know who files it.
I'll look into that. If the defense isn't going to do it, we're certainly going to.
Okay, so Ms. Strong,
Yes,
I think that you might need to file the motion for a new trial.
okay,
I'll grant it. It reopens the case as if it's just, it opens anew. And I think that at that point, they're probably gonna end up just kicking it. And then we're all set and
Dismissing
done.
it?
Yeah,
okay.
to undo the
I'll
mistake.
file that today.
Cool. Okay? Done.
Thank you, Judge. And then Judge Fleischer, did you need me to come in person tomorrow?
No. Just, I'll text you the cause number so that you have
Oh,
it.
wait, once breaking up.
I'll
So yeah,
text
I'll
you.
file the motion for new trial. And then what else do I need to do after I file the motion for new trial?
That's it. Just let us know you filed it so we can put it in the queue and I'll sign it and I'll grant it. And that's it.
Thank you, Judge
And then
Fleischer.
we'll
It'll
let
be
you
in the
know,
queue.
and I can email you to let you know that it's all said and done. But thank you for bringing it to
Perfect.
our
It'll be
attention.
in your queue, by noon.
Okay. Well, no, Ms.
I
Strong,
appreciate
take your
it. Thank you for
time.
calling me, Judge.
Really.
And also, okay, I'm so sorry. Okay, so I
Look,
saw
look,
that
but let's not, don't worry about it. Everything's good.
Okay.
Don't worry about it, Ms. Strong. You're doing great. Okay?
Thank you, Judge.
Thanks.
Okay, I'll file it. Thank
Bye.
you. Bye.
Okay,
Thanks,
thanks. Take care.
Thank you.
Yes. Judge number 2.
Judge, how are you?
Hey. Are you ready?
May we approach you?
Please.
Thank you.
Good morning.
Morning, Judge. I have a gentleman by the name of Kayuba Thomas who is with us today. He has a warrant. It's kind of questionable, but nonetheless, he does, and he wanted to turn himself in.
Okay.
I wanted to see if depending on probable cause, if you did set a bond, whether you might consider a PR bond because his medical condition.
Don't worry about it.
Gotcha. Would you like him brought up,
Just-
Judge?
Please.
Okay. Mr. Thomas?
Yeah. Judge Powell, do you have the cause number by chance?
I think Abigail has it.
I do have it, yes, Your Honor.
What is
Ready?
it? Yeah.
It is 2555058.
Did you get it?
Yes, no problem.
Yes, Mr. Thomas. Coming up, Mr. Thomas. Good morning, sir. Sir, you were charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay?
On February 6, 2025, the officers interviewed the complainant, who stated that on January 18th, 2025, the defendant came into the 5-minute oil change located at 747 Gary Ashford Road in Harris County, Texas, to have maintenance performed on his vehicle. The defendant let the complainant perform a cabin check on his vehicle, so the complainant got inside the vehicle. The complainant and defendant then exchanged in a verbal exchange because the defendant was upset that the complainant was inside the vehicle. The complainant's manager interviewed and attempted to de-escalate the situation, and the defendant told the complainant's manager, "I'm going to come back here, you better correct him before I come back here. I'm going to come back here and I'm going to finish him off with a gun. I will fucking come shoot you all. I will do a drive-by." The complainant confronted the defendant and told him that he was not welcome back. The next day, the defendant was captured on surveillance footage at the location speaking with the complainant's coworker, who informed the defendant that the complainant was not at the location. The defendant went into his armrest and the witness stated that the defendant went into his armrest and he pulled out his gun while uttering the words, "Because of what happened yesterday, I should have shot his ass," referring to the complainant. The defendant stated, "I'm going to come every day until I see him."
And Judge, that's simply not true. In fact, I have his.
Remember, this is a probable cause.
I
To
understand.
start getting into more stuff, I mean, my only concern is, was there a terroristic threat, right?
Exactly,
And
exactly.
I don't know, it looks like there were potential multiple threats. So which one is in the charging instrument? Is
I think the one alleged to have occurred on is,
on the actual day in question when everything,
I can look and
Yeah.
double check.
because what I have, Judge, is just a receipt from when he paid. And because of the way he was treated, they gave him a $20 discount. It shows on the receipt as well. So, he had told them, "Don't upsell me, don't upsell me." He comes around the corner and the guy's in his car. So that's why they gave him the discount on the receipt.
but I mean,
Even so,
Did-
Your Honor, a discount what happened.
No, I understand.
And just to clarify, it is the first threat on
first
January
threat.
18th.
Yeah, I mean, it's,
It is what it is. I understand.
so Mr. Thomas, I'm going to find that there's sufficient probable cause to go forward with the case. The only thing I'm going to ask you to do is don't have contact with the complaining witness, don't be in possession of weapons, and don't go back to the 5-minute
5-minute oil.
Yes,
The
sir.
5-minute oil change. That's all I'm asking you to do, really. Just don't have weapons and don't go back, okay? That's it. As long as you can. Of course.
Alrighty. Anything further, Judge?
No, we have to do bond.
Oh, I'm sorry.
Am I putting me on a PS?
Judge, could I get a call?
Sorry.
It's already set at $100.
Oh, it is? Okay, so I don't need to. All right.
Yes, sorry.
So, Mr. Thomas, I'm going to grant you a PR bond today. You have a bond set at $100. I'm going to grant you a PR bond. All I'm asking you to do is just don't pick up any new cases. Just be nice. It's not hard. You've got a great lawyer here. Listen to him. He'll take care of you. I'll waive your appearance because you have a lawyer. You don't even have to come back. Just stay out of trouble and just, that's it.
Okay, thank you very much, Judge.
So I don't let him, I need you to sign a bunch of paperwork. We have bond conditions that we're going to create. I need you to sign them. Do not leave until you sign our bond conditions. You'll have to meet with Fleischer for your PR bond. And after that, you'll be free to go. Okay? All right.
All right, thank you very much, Judge.
And then, and Judge Powell, do you?
Yes, sir.
Attorney record, please?
Yes, sir, certainly.
We have him over there in the tower.
Okay, thank you.
Judge, I need the cost number.
2555 058.
058.
Yeah.
Thank you. All right.
Marcos, you ready?
Yes, Judge, ready for play?
Yeah,
Mr. Salvador, may I bring my client?
please.
Salvador?
Buenos días. Nosotros hemos adversos como una plática.
Good morning, Mr. Salvador Mejia. Sir, you are charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 3 days in jail with credit for the 1 day that you have done. You need to understand that this DWI will go on your record. It will be there for the rest of your life. It's even there after you die. This is important because if you get pulled over in a car, an officer comes up to your window, they see that you have a prior DWI and they smell alcohol on you, or they smell anything funky, it's probably not going to go well for you. What we're doing today, the proverbial slap on the wrist, will not happen again. From now on, it's a minimum of 90 days in jail. Do you understand?
Yes, sir.
You're giving up the right for trial. Held witnesses to testify on your behalf. Confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this agreement, you can never change this. Do you understand?
Yes, sir.
You still want to do this?
¿Quieres ser este convenio? Yes.
Is it true
¿Es
or
verdad
untrue that you
o
had
no
a
es verdad
5 or
que
above?
tenía un 2.5 más? ¿Verdad o no verdad? ¿Verdad o no verdad?
Sí.
¿Verdad o no verdad?
¿Verdad?
True.
Answer. All right, sir, I'm going to find you guilty. I'm going to sentence you to 3 days in jail, give you credit for the 1 day that you've done. I am going to suspend your license for 90 days.
Yes.
Do not drive until you get a license. And I'm going to tell you now, I will waive the $4,500 surcharge that normally applies in this type of case because we all make mistakes. But if you continue to make mistakes where you endanger other people's lives, a second DWI not only is a minimum of 90 days, but it's a $6,000 surcharge. Do you understand?
Yes, sir.
All right, good luck.
Thank you, Judge. Have an excuse?
Thank you.
Good morning, Your Honor. How are you?
All right, now, how are you?
Yes, Judge. Yes, Judge. Yes, Judge.
Who you got?
Approaching on Joe Brandon, Your Honor. Mr. Brandon, his appearance was waived, but wanted to discuss bond conditions with you.
The new driving one.
No, Judge, actually, no. You made it clear on that one why you would.
I don't even remember, but tell me, what do you want?
There's a reckless driving, but there's other things going on. You also put him on a monitor with a curfew. It has been over 3 months since this allegedly occurred on December 15th. We are not arguing the no driving part of this. We understand why the court's doing that. But with regard to the curfew and the monitor, we'd ask that the court consider removal. Well, I mean, if we take away so he can work.
Does he work in the middle of the night? Does he work in the middle of the night?
Judge, his his proposed shift that he's trying to get is going to carry over into the night hours. I mean, I would ask for amendment of the curfew, but if we get rid of the curfew, there's no point to having the monitor.
So let me know if he does get that, come back and we'll talk, and I'm happy to amend.
Okay.
You know, he's been doing good, I'm assuming.
Yeah.
Okay. Yeah, I'm happy to work with you for it. You know, if he does do it.
We understand the no driving. I'm not going to ask you about that
It's
again.
okay, but if he does get it and he needs those work hours, I'm happy to do it.
Judge,
Yeah, okay, for sure. Counsel.
So real quick, I just put up a poll where, Judge Fleischer just said the guy made a mistake. Judge Boyd is famous for saying that people don't make mistakes, they make bad choices. So take a look at the poll and let me know what you think. Are defendants guilty of making mistakes, or are they guilty of making bad choices? Because they're not exactly the same thing. Let's get back to Judge.
Mr. Rivera speaks English or no? He just.
So the first thing I'm going to do is I'm going to send him for a drug and alcohol test right now.
Okay, Your Honor.
To send him for a test to see what, if anything, he's going to test positive for. We'll have him come back and then we can deal with the bond violation.
Correct, Your Honor. Yes.
Yeah.
Yes, Judge.
I'm sending Mr. Rivera Mendoza for a test, please.
Yes, Judge.
Does he go back to the box, Your Honor?
He should only need to sign conditions.
Thank you very much, Your Honor.
But he has to come back. He has to come back. Okay.
Well, there's a break in the action there. Let's go back to Judge Simpson, who's had a busy court all morning long.
So I have two people, I just didn't want to name.
That's twice in 2 days he's done that to me. I flip over to him and he hits the mute button. I'll go back to Judge Fleischer for a moment.
Yeah.
I just cut out. He has a scram. Do you need to sign anything to remove that?
No, once they see the order has been done, he just needs to go to, I thought the 7th floor. No. Ask Felicia, she'll know more.
Okay, thank you.
But once the order entered and they see it, at that point, though, he can go. I just don't know where.
Oh, sorry. Thank you.
Yeah.
Council for recess.
Let's go over and visit with Judge Boyd for the first time this morning.
So I know. Your Honor, good morning. We've had an opportunity, counsel and I have had an opportunity to confer this morning. with regard to particular ideas that I'd like to talk to the board about.
Okay.
One of those ideas was ultimately to bring the director of a program that I'd like to talk to the board about. And I believe the director is certainly willing to come in. I had not talked to the director about his schedule. I will contact him as soon as I leave court today to see how quickly he can come in. I do know Mr. King. He will make every arrangement to try to come in at the court's
Okay, so
discretion.
here's my question.
What is with all of these judges hitting the mute button all of a sudden? It doesn't make for good entertainment, judges. Let's go to Judge Meineke. He rarely mutes.
We're adjourning it because my client is out of the state, actually. So when this offer was made, he needs to get another opinion from the Georgia attorneys that he knows down there before I can even give him advice on taking this deal or not. So we do have a resolution worked out, but again, I'm not in a position to advise him on what could happen with this Georgia license. Also, Your Honor, I did want to ask, and I did bring this up to the city attorney, because he's from Georgia, the testing is very it's expensive. He can't go to a local place. It's really hard for him to find a place, drive there, pay the extra fee for them to send it over here. And then there was an increase in frequency or something. Your Honor, if we could reduce the frequency, he has a valid medical marijuana card. He has no alcohol issues at all. He's following all of the rules of bond. It's just becoming excessively burdensome for him. He's not on an income, Your Honor, right now. He actually suffered from an accident a few years back. And so he's not working right now. It's becoming extremely burdensome and difficult for him to even operate at this point. And he has no bond issues.
Well, I mean, as you can imagine, that you know, the challenge for the court is that the reason, the main reason would be because it's more expensive out of state. To be fair, because I let him leave the state. I didn't have to do that, and he came to our state and had this incident. So like it's a little bit difficult to feel super sympathetic when you know, obviously that the testing is cheaper here, and you know, I want Mr. Cromer to continue to push forward in his life. If I recall correctly, I had him on a SoberLink device, didn't I? Your
Honor, he couldn't afford the SoberLink device. I think they wanted over almost 1,000 or something a month. He couldn't afford it.
So it looks like he's tested on February 18th and March 4th, but only for drugs. So I don't have an alcohol screen from him for an extended period of time.
Okay.
I turned that into them.
So
that's they have that stuff.
Who does?
The bond lady, the bond women, like that's the whole mix up, because here in Atlanta, I was at first, I have to go one facility and then drive another 45 minutes to another facility to take the test. Now I found a facility that does both of the tests, but that's 45 to an hour away from my house. So I got to drive there to take the test.
Okay.
They sent it over. They sent it over. It was a mix up. It was a mix up between because I guess when they sent it over to the first Nova Medical Clinic, she was like, I couldn't keep switching facilities. Yeah. Once I came with that facility that's an hour away but does both of them, I guess they haven't updated the information, but I just tested last week and gave it to them.
Okay, so let me walk through this. How often are you testing for alcohol?
Every time I go there I go once a week to the place.
Because so originally he was supposed to be testing twice a week for alcohol, and it looks like twice a month for drugs. I don't know that there's a need for twice a month drugs. Once a month would be sufficient. Twice a week ETGs. Again,
the thing
wait,
is,
D'Angelo, stop.
I'm walking through this, trying to figure this out. So if he's doing, twice a week is an appropriate amount for him to be testing, but that would be very expensive. I have no doubt about that. So
All right, so do each of these so previously you were testing at one facility for alcohol and one facility for drugs, is that right?
Yes, sir.
And you have found a facility that does both?
Yes, sir.
All right, okay, but that's one that's 45 minutes away.
It's 45 minutes to an hour away with traffic. Atlanta traffic is crazy. So it's because I live on the north side of Atlanta. This place is on the south side of Atlanta.
Okay,
So
how
it's like
much, how much is the test? How
I
much is
gotta pay.
alcohol?
I pay 105.
And that does both?
Yeah, because they only do both. The testing that they offer, you can't split it up. It's offered in this like package that they have.
And the place that you were testing just for alcohol, how much was that?
When I was going there and it was just doing the alcohol, it was 150.
150?
Yeah.
Your Honor, I mean, I would be mad if I had to pay some of those prices, Your Honor.
But see, the place that I go to now is together with both tests, they charge me 105, but that's every time I come. So if I go,
He gets it, D'Angelo. He gets it, D'Angelo. I think Judge Meineke, he understands. Thank you.
So basically, so basically right now, without the sober link, he's supposed to be testing 9 times a month, which would be actually 10 times a month, twice a week for alcohol, twice a week for drugs, but he's paying the same price for both anyway. So that works out to be 10 tests. That's $1,000. And so is that the kind of money that you're having to put towards this, Mr. Cromer?
Yes.
Okay. So,
And Your Honor, he's borrowing money from friends at this point, just not to get in trouble. I don't want to see him go down that road where, this becomes a burden on everybody he loves.
there's no way I can delete his testing. 0.0%
No.
chance that I can do that. So what I can do though, for Mr. Cromer, is I will reduce, he's supposed to be testing 8 times a month for alcohol and twice a month for drugs. He found a place that'll do both. So I will just make it 3 times a month. That's it. That is as low as I possibly would go at this point in time.
No, that's fine.
And
Thank you, Your Honor.
and obviously he's doing a drug test there anyway, because it's a combo with the 105. So 3 times a month, drug and alcohol, and that's what we'll do for now. And again, Mr. Cromer, that is way less than I would be doing, but I'm trying to recognize just the sheer impossibility of continuing at the pace that we're at. But that means you can't miss your tests. You can't have any positive tests other than what I obviously am aware of with the medical marijuana. Okay?
Yes.
Thank you, Your Honor. There's always some gaps in the system, Your Honor, but we fix them, right?
All right. Well, we'll see everybody back here in 4 weeks.
Thank you, Your Honor. Have a great day.
Good luck, Mr. Cromer.
Thank you.
Okay. Mr. Dean, while I'm managing the Hector Alexander file, do you need to speak with Parker?
No, we're ready to go, Your Honor. Thank you.
Okay. And then Ms. Casca, same on Duncan. I have to deal with one with the interpreter so I can get the interpreter going.
Let's go ahead and go back to Judge Fleischer for a little bit.
All right, well,
Thank you very much. I mean, I guess, Your Honor, my thing is it's a public record that they're using DIMS taking the offense report. And also, I have never seen it before where we have to rely solely on the DIMS for probable cause. It's probable cause. In fact, when we go to the grand jury, that's all offense report, that's all DIMS, it's everything that comes in, it's even evidence. And that's probable cause.
Yeah, I don't know. I don't think that. I mean, let's look, because I don't know,
Okay, I'll stand
And
down.
I'll
Go check with
Sure.
Ms. Rogers.
Hey, you ready? Come on.
Yeah, I just want to approach on bond conditions for Mr. Bardan.
Okay.
BARDAN.
So you got appointed Mr. Albardan?
Yeah.
Great. Okay.
He has a residency restriction to stay away from his father's house. That's where him and his siblings live. And I want to approach you about lifting that up to no harmful or offensive contact.
And I'm okay. So he's Mr. Albardan. Come on up. Your lawyer wants me to change the conditions so that you can go back to the house. But I want you to understand that if you have a very tumultuous relationship with these people where you're always butting heads with them. It's not going to go well. I don't want you to have any threatening or harassing contact with them. What is threatening or harassing doesn't matter what you think. It is what they perceive. So if you go like this, is that threatening or harassing? It most certainly is, and it can land you back in jail. Do you understand? So if you cannot be nice and if you cannot get along with brother and sister or dad, be very careful. Because if I get wind that it's not going well and that you're threatening or you're putting anyone in danger or you have a weapon, I will put you in custody. You understand? Okay. All right. I'm done.
Thank you, Judge. I'm excused.
Thank you. The only, so, Mr. Albardon, the only thing I'm taking off of the protective order is the residential restriction. Everything else in the protective order stays. So if you threaten them, if you harass them, they can charge a new case on you. Do you understand?
Yes, ma'am.
Okay. All right.
I will convey that.
And if you can file, no, now we need,
State bond condition.
yeah, so, Mr. Reedy, we need new bond conditions. He can't leave just yet, so we need him to sign no
Okay, I
threatening
thought
or
you were
harassing.
put right there, not to leave.
Okay.
Is that for your bond? Because you went here.
Yeah. Stay.
I heard.
Okay.
Wait, wait.
How are you, Judge?
What's new, man?
Same old.
Did you pick a day?
Well, I have Monday and Tuesday are not good for me. Wednesday or Friday of next week is fine. I mean, I have a few days every week.
All come together with a meeting of the minds?
I think it's from what it sounds like, our officers we need two officers. One is.
Yes, one is unavailable on Wednesday and the other officer is unavailable on Thursday and Friday. I've reached
So
out
go
to
into the
both
next
of-
week.
Yes, yeah, okay.
I don't
I've reached
care.
out to both of them to find out their availability for next week. I'm just waiting to hear back. The next week after that.
Okay.
Yeah.
Okay.
No stress, man. We have enough drama. Just pick a day. I don't care.
I'm not
Just
looking
make
for
sure that, like, I don't want to keep doing this stuff.
No,
This is
that's-
like,
that's
this is the
why I
last time.
Before we said, hey, go next week.
If we set this for the next hearing and one of the officers comes back and says, I'm sorry, I can't do it. I don't give, we're going forward without that. All right?
All right.
Whatever you want.
All right.
Of course.
Sure.
So that information you were telling me about for the VPO?
Not quite, we need it.
Cheryl Diggs was the magistrate that signed the original bond conditions.
Right,
Got
but
picked
this is,
up. Would you like us to amend it?
no, it's not you, it's them.
Yeah.
So let me, I'll bring it up to them in a second.
Okay.
Ralph,
Oh, yes, sir.
hey,
I've got Mr. Basie and the state would like to evaluate it. It's an old case, Your Honor, but they asked if we could reset it, which I'm in agreement.
this is an interesting one.
Right, it really is.
A week. We filed for a week.
Yeah, sure, yes.
Do you have an offer on the case?
Just want to do one, just the,
Yeah.
I just want to do one little case law.
Not a problem.
thing. I think.
Is discovery complete?
Discovery complete.
You've got an offer?
I think we're gonna be able to resolve this case.
Okay, so I guess set it for next week. And then we'll come back and,
Want to do one more little case law.
no problem.
Sure, thank you both.
Hi, Ralph.
Judge, for Al Bardon, their state's conditions, correct? Oh. I know, I heard say it's your next meeting.
All right, let's try Judge Simpson again for a little bit as he continues to work through an incredibly busy docket this morning.
Sentence investigation and report is ordered at 14A1 probation. Sentencing will be April 30th, 2025, 12 noon. That's before me. All right. Defendant's bond in this case will continue. All right. Thank you. And he might want to, my probation department's right down the hallway on your left. You may want to just stop down there and check in with them and get it started. All right, thank you. Court does call the case of the people versus Candace Huddleston.
Joseph Condola, people, this is the public defender Jay Long on behalf of Ms. Middleton, to approach Your Honor. So, please state your name for the record.
She has a medical marijuana card. Okay. What are we doing? You need an adjournment on.
We are requesting Mr. I have talked to Mr. Condola about saving the audio for the body worn cam. I'm not sure why it was submitted without audio. It's concerning to me considering the officer involved. So for that reason, we'll be requesting an adjournment so I can look further into that. I might be submitting a motion for
Okay. All that?
all that.
All that. April 10th, 2025,
Thank you.
9 a.m. All right, thank you. Bond continued. Court calls case, People versus Craig Jones.
People. Senator Alexis, on behalf of Mr. Jones, who's approaching. Mr. Jones, could you just say your full name?
Craig Jones.
Right.
Your Honor, we have worked out a global resolution of Mr. Jones' cases. A part of that resolution would require him to plead on his 2 misdemeanor cases before we resolve this
case.
Those are not set until April 2nd and April 10th, so if we could go to the 17th, that would be perfect.
That's correct. We have 2 pending domestic violence cases which needs to plead on in order to resolve this.
Gotcha. All right. Probable cause conference, April 17th, 2025, 9 a.m. or as your invite indicates, bond will continue. All right, thank you. Court calls the case of the People versus Lamar Jones.
And then on behalf of the people, Your Honor.
Brian Bowling, on behalf of Mr. Jones, Your Honor. State your name there.
All right, thank you.
Your Honor, we've reached a resolution in this case. Excuse me. That would be for Mr. Jones to plead guilty to counts, I believe, 5 and 6. Misdemeanor count.
That's correct, Your Honor. We agree that count 6 would be under sentencing under 4A.
Council approach. You've seen the bond.
So let's cut back to Judge Fleischer. They're debating DIMS reports and officer reports and how it all fits into probable cause. Catching it in the middle, but let's see what they have to say.
It's a government record that this officer is doing his main office. If he makes something up or if he lies about something, that is a crime.
Right, but filing a false government document is different, a different crime than perjury.
I get it, but
Wouldn't that be filing a false,
Right, but perjury's
an official document?
a different crime.
No, but it would also under the purview of filing a false,
Well, Judge, if an
Filing a
officer
false-
came into court and was asking for you to sign a search warrant, and they just gave you their offense report, that would not be enough for their search warrant. And it's kind of the same idea. Because this is a warrantless arrest, there has to be someone swearing to the facts to support probable cause for that arrest. And similarly, with the search warrant, it has to be supported by over affirmation. This wasn't a warranted arrest. It was a warrantless arrest. And so it must be supported by probable cause. That includes an affidavit.
Was there blood in this case? Right. Okay, give me 5 minutes.
Okay.
Huh? Okay.
If it's okay with you, we'll take.
Can you show them?
yeah, that's fine. Yeah.
I'm done with everything. I just, because you have state conditions.
Okay, so I picked that one up kind of in the middle because, again, I monitor like 10 different things at once, so I didn't catch it right away. But it looks like the defense attorney is challenging how probable cause was established. If I understand this correctly, there's the DIMS report, which they generally read through for probable cause, but then there's also another report, and there's a question as to whether or not that one was properly brought in for probable cause. So it's a little confusing, but it's intriguing, and these are the kind of arguments I like. So what I'm going to do after the live stream is I'll go back and I'll rewind it, see what that content is, and if it's what I think it is, I'm going to do a separate video on it later today, so be on the lookout for that. Let's go look at Judge Boyd now for a few minutes.
To supplement pending motion to revoke probation with your attorney, and did you understand it?
Your Honor, if I may, we have
Yes.
not had a chance to review that document. Mr. Reina is asking to have a bond set and time to hire an attorney.
All right, so y'all need to review the document and then approach. Thank you.
Thank you, ma'am.
You're welcome. They're not ready. I'm working. I'm not gonna do duo. Well, maybe I will do Duolingo. We'll see. Gennaro? Okay, see, even he pronounced it wrong. How am I supposed to learn?
Make it the English version.
Okay. Oh, okay. All right. You all need to go over the alphabet with me. Who is here on Isaiah Gibson? Did I pronounce that correctly? All right, where's Mr. Gibson?
Judge, I think we have a plea of true with their proposed resolution.
All right. Court is calling 2022 CR 1156 State versus Isaiah Gibson. Can I have parties announced for the record for the state?
Eileen Galloway for the state.
Robert Mauer for defendant.
And are you Mr. Gibson?
Yes, sir.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? And did you understand it?
Yes, ma'am.
Are you the same Isaiah Caleb Gibson who was placed on deferred adjudication in 2022 CR 1156 for the offense of theft $30,000 to $150,000 on November 16th, 2023 for a period of 8 years? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 2 on or about the 22nd day of March 2024 in Bear County, Texas. The defendant, Isaiah Caleb Gibson, failed to submit to your analysis as directed by supervision officer in violation of condition number 2.
How do you plead to that? True or not true?
True.
State.
We waive and abandon the remainders, Your Honor.
Any objection?
No, Judge.
Do you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, ma'am.
Court will find violation of condition number 2 true. Is there a proposed agreement?
There is, Your Honor. After conferring with probation, the proposed agreement for the court's consideration is to deny the state's motion, alter and amend the defendant's conditions to reflect intensive allocation, ISP high-risk caseload, sober support meetings, and then the UA hotline for at least 60 days.
That's your understanding, Judge, but ask the court to follow it.
All right, you want to raise your right hand for me? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Isaiah Antonio Caleb Gibson.
All right, why are you not doing well on probation?
I had housing issues at the time.
What are your issues?
Well, I didn't have nowhere to stay at the time, and I didn't want to call nobody for help, thinking I could do it on my own. And me and my mom wasn't seeing eye to eye. Well, I wasn't seeing eye to eye with my mom.
His mom's here, Judge.
Okay.
I just never really called to ask my mom, because every time I called, ask my mom, she always gave me hard love, and I didn't like that, and I wasn't accepting that.
Well, how old are you?
I'm 27.
You got to get your life together instead of spending all this money on tattoos.
Yes, ma'am.
You understand?
Yes,
You can spend money on tattoos if you have a place to stay, but if you don't have a place to stay, all of these luxury items, you shouldn't be spending money on that. And I'm sure your mom is just tired. Like, how many times can your mom tell you to do what's right?
She didn't have to tell me what it wants. She just had to tell me at all, honestly.
Mhm. So it's like, how many times must she do this? I'm sure she didn't raise you to be on probation and to commit criminal acts.
I know she did.
All right, and then there are other things in the motion to revoke, and I'm assuming that's why you all are addressing it with intensive outpatient treatment or want to do that?
That's correct, Your Honor.
All right, so here's the thing. Marijuana, my understanding, not from my experience, but what I've seen from television, maybe Menace to Society and other programming. Marijuana, usually you just around a group of people and it's puff, puff, pass, and nobody's charging anybody. But maybe somebody will bring a drink, you know. But usually for cocaine, that costs money. That you've been spending it on that. You need to get employment and get your life together. Do you understand?
Yes, ma'am.
Now, I'm going to give you a choice. And the reason why I'm giving you a choice is because I'm being told that this is what probation is recommending. Is that correct, probation? So here are your choices. I will send you to prison for 2 years. You go do your time, you come out. Maybe you change your life, maybe you don't. You'll just be another person who went to prison. Or I can follow these conditions. But if I follow these conditions and you come back before me, you're looking at up to 10 years in the prison. So those are your two choices. You can either do the 2 years in prison today, or I will follow the agreement that has been reached. Do you need to discuss that with your attorney?
No, ma'am.
So what do you wish to do?
Follow the agreement.
All right, this is what the court is going to do. The court is finding violation of condition number 2 true. You are going to get employment, and part of it is I'm going to want employment for him. Of course, probation, no harmful, no product, sorry, no employment as a home health care provider or with minors. I know that I've stated that previously with you. And you're going to have employment within 30 days of release, and knock your pride aside, because I know they're hiring at McDonald's, and they're just hiring anybody at McDonald's now because their fries don't taste the same. But I know they're hiring there. I know they're hiring at Burger King. I see so many signs saying help wanted. And what I can tell you, McDonald's, I don't know about Burger King, but I know at McDonald's, they will pay for your higher level education.
Bill Miller as well.
And Bill Miller's as well, which they removed right from downtown. Now we have to walk extra, but.
It's not real barbecue.
All right, as a side note, do you know, when I first came to San Antonio, because Bill Miller's was on every corner, I thought that was the barbecue of Texas. I tried it. I'm just gonna let that sit there. All right, it's fine. All right, you're gonna have employment within 30 days. So when you get out of custody, you need to hit the pavement running to get employment. Probation will give you a list of places to go to as well. And if you are not able to get employed, you had better show at least 5 places per day where you've tried to get employment. Do you understand?
Yes, ma'am.
There's going to be intensive outpatient treatment with probation. And you are going to do the UA hotline. You're going to have to call in. So either you're going to have to get a cell phone, somebody to loan it to you so you can call in, or either you're going to have to go down to probation, use their phone to call in. Do you understand?
Yes, ma'am.
And there's going to be field visits until further notice. And that will be 1 time per month until further notice. Is there anything else, probation? All right, and you'll be on ISP high risk caseload. Anything else, probation? We'll start with once a week, and we'll do once a week for 3 months. And if there's a positive UA, then of course the motion to revoke will be filed. If there's not, then we'll move to at least testing once every 2 weeks, and we'll do it in those increments. Is there anything else you need from me to be successful?
I have to get an ID when I get out, and use the DMV, and you put a appointment in, it's like 2 weeks or a month in advance, and then after you put your appointment in. So that
I will
might be
tell
the
you
only
this.
delay.
If you go in and you talk to people and you present them with, I'm trying to improve my lot in life, I desperately need this ID. The judge is telling me I need a job in 30 days. Sometimes people will work with you. I ended up going to get my license and I thought it would be an easy thing to do. I didn't know you had to set an appointment. And we can go off the record, my license was going to expire like the next day. And so I'm like, oh, it'll be fine. I go in there, line is out the door. It took me 45 minutes to actually find a place that was open because they have places like, this is where you go to do your license, and it wasn't. I find it and I tell the lady, I said, I had no idea we had to sign up. My license is going to expire tomorrow. Can you help me? You know what she said? Tell you what, it's going to be a long wait, but just stand. I'm like, fine with waiting. I was there for about 2 hours, and I was fine with being there for 2 hours because they were helping me. So express yourself and tell them the desperation with which you need it, and you get it.
Just gonna say, and I think if you can at least show that you're going and applying for jobs, that you're making the effort while you're getting your ID, I think that you can show that to probation, will show the effort. What she doesn't want you to do is just decide you don't have an ID, so you're not gonna do anything. So you gotta
Yes.
get motivated.
And then when they interview you and they ask you, when can you start working? You know what your answer should be? Now. You understand?
Yes, ma'am.
All right, and stop breaking your mom's heart. I'm sure she doesn't want to be here today for this.
Yes, ma'am.
All right, good luck to you.
Thank you, Judge.
You're welcome.
Excuse me.
Yes.
See you at one, Judge.
All right, thank you.
For sure.
Yes.
We're ready on Brandon whenever the court's ready to address him again.
All right, and what's your client's last name? I'm sorry.
Reina?
Raina?
Renato Reines?
All right, just give me one moment.
Courtroom.
So while Judge is getting ready for the next case, well, we were off to a breakneck start this morning. I went live about 15 minutes early because every court was just stacked. Everybody is quiet now, so we'll ride with Judge Boyd for just a little while longer. But several courts are in recess. Many of them have finally worked through their backlog. Judge Fleischer is still in the back. He's been in the back for 10, 15 minutes now, talking with attorneys about the probable cause and the issue with the paperwork or whatever. Again, I'm going to take another look at that after the live and see if it makes any sense to do a video on that. But let's cut back to Judge Boyd for a little bit.
The thing is, her new apartment center by Wall Street, that's where the medical school is.
Mhm.
And they have extra security right across from her apartment.
Oh, that's awesome.
Yeah. But I told her roommates are mandatory.
Okay.
She's like, she found the apartment of these two other girls, but she doesn't really like them. And I told her I don't care.
There you go.
She said, you're not gonna be there anyway.
All right. Could I see the case on Gennaro Reina, please? All right, if y'all will come up on Gennaro Reina. Do I still have it?
Oh my God. How you doing, man?
I'm doing okay. No, the only person I have up here is De Jesus and Dean. Oh, no problem. All right, so where are we on this motion to revoke?
Your Honor, you had asked me to review the motion with him. I did review the allegations on both the original motion and the amended motion.
All right, are you all ready to proceed on the motion to revoke?
Your Honor, Mr. Reina would like time to hire an attorney and seek the court setting him a bond. I've explained to him his rights as far as being true or not true today and what that would mean.
All right,
That
so-
said, we're prepared to proceed as much as possible.
All right, so then what we'll do is we'll reset this so you can hire an attorney, and that attorney will take up any bond matters. And we are bringing this back, Ms. Ferguson. Bring this back in 10 days for a contested hearing. Whoever you're hired needs to be prepared for the contested hearing.
You understand, Mr. Reina? Thank you, Your Honor.
All right, what date, Ms. Ferguson?
Can
All right, so we're going to be back on March 31st for your contested hearing.
Can I say something?
Sure.
Can I have a bond that I was?
You need.
Let's go back to Judge Fleischer. He's back from hiding.
Because you're gonna head down to the first board of elections, and then we with this room, so they do it for today. So, just put down there, you can look at it.
We have court orders for a reason, and when you don't follow court orders, bad things happen. Do you understand?
Yes.
You were ordered to get an interlock and you didn't get it, or a portable device, and you didn't get it. That's unacceptable. When you don't, there are serious, serious consequences. The only thing I'm asking you to do, don't endanger my streets. Don't kill someone on the road. Do you understand?
Yes, sir.
I'm going to find no probable cause in your case now. But if you come back with a new case and you don't follow court orders, it's really not going to go well for you. Do you understand?
Yes, sir.
All right. Good luck.
Thank you, Judge.
I think that we are, you know,
Sorry.
it's okay. No, and I think you're right, you know, we were going through the lawsuit and, you know, 2017, the county came into an agreement where we're basically holding it to a higher standard, so to speak. I mean, theoretically, could I weasel out of it? Yes, but I don't want to, you know, I want to stick with the agreement that the county came to with the district attorney's office, you know?
So, not saying it's this, I'm just for curiosity.
The DIMS has to state an offense, right? It has to say, it has to have all the elements of the offense to go forward. The reason, I mean, I would presume that offense reports don't is because they're continually just updated and they're amended and they supplement it. So it would be unreasonable to have an officer every single time they swear to over and over and over and over, because shit, you might get like 15 supplements.
And here's my question then for the board, and with, I'm not saying we're gonna do this in this case, I'm just saying for cases going forward. To me then, does that then behoove, does that say we can't take it to grand jury? I mean,
You can, of course you can.
So.
Just because I find no probable cause on something, if you want to go indict it, go do it.
Right, okay.
Absolutely. There's nothing barring you from doing that, right? Because if a grand jury finds something different, then that's on them.
Yeah,
As far as me, I'm going to just hold to the standard that we agreed with the county and the lawsuit.
Yeah, I'm just, and this is for my own.
And you, look, you're not going to hurt my feelings if you go to a grand jury. I don't care.
I know you did.
Oh, really?
I just, so we wouldn't be held to that same
You need
standard.
you need to do what you think is right.
Okay.
Like I'm going to do it, and like
Absolutely.
she's doing it. The problem is that whoever had the apps, they didn't dive into it and really look into it as Anna did, you know? Not everybody is, which is good.
Thank you.
God love you. All right. Hi, Shreya.
Hi, Judge.
Oh.
I'm Miss Lovey.
Okay.
So I wanted to address the BDR.
So real quick, while he pulls that up, I'm going to have more to say on what we just saw before Shreya here in just a minute.
So here's, Shreya, here's what we're going to do. I'm going to send her for a drug and alcohol test now.
We already did. She came back negative, Judge.
Oh, great. Good job. But if you miss again, it's not going to go well.
So
It is your responsibility to let Shreya know if you're going out of town, if you have some other obligation, because we can always work something out. But I'm not going to continue to do this. If you miss again, it's just not going to go well for you.
So Judge, that's what we want to talk about. So when I was first appointed to her, Ms. Lovey talked to me about her work schedule. And I said, look, let's just wait and see what happens with the UAs. If you get called in for a UA, but you have work, I don't want you to lose your job. I told her that. Yes. So
They give you a sufficient amount of time to come.
same day.
Yeah, there's 6 hours.
Yes. So she's a behavioral technician at Action Behavior Center.
Yes.
And she cannot take off work.
They penalize me.
So, and do you want to talk to the judge about that?
Yes. I bought some printouts as well on my works attendance policy.
So we have like a 2 weeks ahead of time type thing. They'll let me off. I had to beg and say it was like a life emergency just to get Thursday. I also have asked before because I remember the original court date was for Tuesday, the 18th, I believe. And 2 weeks ahead of time, that court date, I wasn't scheduled to appear. And I said, since I missed that UA, would it help for me to appear in court that day, even though I'm not required to come, to show that I'm okay with appearing to test? Testing is not something I'm trying to avoid or anything, but if I can put, time and effort into make my appearances, be here, and also keep my job security, is there a way that we can balance those two things? Because I have no problem showing up and testing or anything like that. I also live in Humble, Texas. So traffic times, I get off work anywhere between 4:30 and 5:30 every day. And I did bring some printouts just in case that's needed of our policies and everything.
I'm not gonna take off the fact that you're not supposed to use alcohol or drugs.
Right.
Absolutely, but is there a way we can schedule her testing? Even if you want
And
her,
that defeats the whole purpose of it being random. You know,
I know.
because that's how we catch people. If you know when the test is going to be, it defeats the purpose of it being random. So why do we do this? Why don't we just work something? If you get called on again, call Shreya, and then Shreya can come to me, and then we can work something out somehow. You know?
Okay, and every single time I will need your work schedule.
Yes, and I have printouts
So
from the
just
missed date as
send
well.
called on, let Shreya know.
Mhm.
Shreya can come to me and we can try to work something.
Okay.
Okay? Because I don't know, you may not get called again. I don't know. You probably will because you missed now, right? But just if and when they do call you, let Shreya know and we'll try to work something out. Okay? Okay. Good luck. Yes, ma'am.
And then we'll just get a reset on
Let's
this.
get a reset. And your appearances, no reason for you to come, unless of course there's a.
So, and I say that, but your appearance was waived, but then when you have the UA, because you can't go to court, then you're gonna have to show.
Okay, yeah. Mhm.
Okay, good luck.
Thank you.
Have a seat.
Want this resubmitted to the court on May 8th.
Dismissing or disposing of it.
Okay.
Okie dokie, fat fingers switched a little weird there. What I wanted to go back to was before that interaction with Shreya and that bond violation. We had an instance there where the judge found no PC, and that was connected to the thing that we saw a little earlier that we cut halfway in on, where they were debating different reports and whatnot. And from what I can gather now, it seems like the DIMS didn't have a specific accusation in it, and they were relying on another officer report to supplement that, and that's where the confusion came in. I kind of wanted to tie it all together as best I can for now, but again, after the live, I'm going to go back, try to piece all that together and see if it makes sense to put it in its own video, because I think there was some compelling argument there that we missed out on a little bit, but that happens when we're monitoring a dozen different courtrooms at once. Anyways, let's go back to Judge.
Monday, if you want to send a letter, to the last known address, and then that way you have a CYA. Or maybe like Tuesday, that way gives you enough time.
Tuesday would be.
Okay.
Thank
So
you.
SFBF Tuesday, okay?
Okay.
If he does not appear at that point, it gets revoked.
Yes, sir.
Okay?
Maybe excuse.
Yes, ma'am. Thanks. Hey, Blaze, sorry, disturb you. I got something else to show you too. This is a 2B. Look at the charging paragraphs.
Yes, I need to re-sign that one.
Yes.
And we'll just shoot them out, sign them.
Yes, sir.
Whenever
you're ready to go.
Wait, leave it.
Great, there you go. Council for reset.
I don't know, do you want to amend it? Can you? I don't know.
I can definitely. See.
I don't know. I don't know. That's why I'm wanted to bring it to your attention. I can't just grant that. So,
Let me take a look at some.
and then, or maybe if you want to reach out to higher ups to see what's the proper protocol. I don't know.
Council will reset.
That's your hired. Yeah, it's still a teaching mode I'm having look at it too.
Did we do a plea on Rivas?
What's that?
I'm not to sign, that's the same document you keep signing, it's just to reinstate the condition.
Why would we stay him? We're still in jail.
Or in the event that you are released on bond again.
Oh. I'm ready to sign.
Yes.
Okay.
Okay, thank you.
I was actually just wondering about him.
I read your mind, Joan. I just reinstated his conditions in the event that he's released.
Yeah.
Okay, pretty much every courtroom that I'm monitoring now has quieted down. Most of them are actually have gone to recess. So I'm going to go ahead and call it a day for the live stream. Thank you again so much for joining us. And again, thank you. I expressed this earlier in the live, but yesterday was actually the biggest day this channel ever had. We had over 200,000 different viewers from around the world visit our channel in one way or another yesterday, and that was huge. And I just want to say thank you. I really appreciate that. But we'll be back again tomorrow live, 10 a.m. Eastern, 7 a.m. Pacific. Please do give consideration to checking out our other content. We've got hundreds of videos out there for you to look at. Lots of good court content. Appreciate you joining again. Take care and God bless.